Hello, everyone, and thank you for joining us today for our ABA Civil Rights and Social Justice Program, How Things Work, the Legal Edition, which is a rapid response project that addresses how our civil rights are being impacted by actions taken by the new administration. My name is Stephanie Baez, and I'm the Director of Pro Bono for the ABA Commission on Immigration, and I'm thrilled to welcome you to this conversation. These videos are a unique opportunity to address what's happening in America today, clarify any misinformation or disinformation that's being spread, and explain how civil rights and social justice advocates can act to protect the rights of everyone. Today's topic is myths about immigrants and crime. This conversation is more critical now than ever as the myth of a migrant crime surge has become common in politics and media. This important issue intersects with the principles of justice and equity that guide the work of the section of Civil Rights and Social Justice and the ABA generally. We're honored to have with us today Wendy Wayne, who's an immigration policy expert with extensive experience providing strategic advice to immigration and criminal justice organizations. Wendy is the immigration policy consultant at South End Strategies, a consulting practice that provides policy expertise to nonprofit organizations and governmental entities on critical issues within the immigration and criminal justice systems. Wendy is also a past chair of the ABA Commission on Immigration. She's a leading expert in the interplay of immigration and criminal justice systems, and we're very grateful for her willingness to share her insights with us today. So now we can go ahead and get started. Wendy, as I mentioned in the introduction, we're seeing a lot in the media about immigrants and crime. Can you discuss what is the reality?
Sure, Stephanie. Thank you for having me on to talk about this really important topic, especially in the increasing criminalization of immigrants in our climate today. I just want to note that I'm going to use non-citizen and immigrant interchangeably, and also deportation and removal interchangeably, even though those terms are technically different. So research has shown over and over and over again that first-generation immigrants commit crimes at significantly lower rates than U.S. citizens. This bears repeating. First-generation immigrants commit crimes at significantly lower rates than U.S. citizens. Second and third-generation immigrants have been shown to have higher crime rates that more closely resemble crime rates committed by native U.S. citizens. However, the crime rates of even second and third generation immigrants are not higher than those of native-born U.S. citizens who've lived in this country for many generations. So immigrants do not commit more crimes than native-born U.S. citizens. In fact, they commit substantially lower rates of crime. It's also critical to note that immigrants living in the U.S. without lawful status, either because they originally entered the U.S. unlawfully or their immigration status expired, are not committing a crime. Being present in the U.S. without lawful status is a civil violation of law. It's not a crime. Being present in the U.S. without lawful status is a civil violation. Despite the increasing criminalization of immigrants and the militarization of immigration enforcement, which we have certainly seen more and more of over the last couple months, the overwhelming majority of immigrants arrested by ICE are being arrested for a civil violation, not a criminal offense. However, due to existing and long-standing racial bias within the criminal justice system, which continues into and is compounded in the immigration system, a disproportionate percentage of Black and brown immigrants are arrested for crimes and then turned over to immigration officials for removal or deportation. This is for a variety of reasons, but since 9/11, immigration enforcement has increasingly been connected to and targeted immigrants within the criminal justice system. When communities of color are over-policed, this results in disproportionate numbers of immigrants of color being arrested for crimes, including for low-level nonviolent crimes. Because the federal criminal and immigration databases are connected, if an immigrant is charged with a crime, ICE is immediately notified. This creates a pipeline from the criminal justice system to the immigration system and continues the disproportionately high percentage of Black and brown individuals from the criminal system being fed into the immigration system. Also, because involvement in the criminal justice system severely limits defenses to deportation or availability for asylum or other forms of relief, this results in disproportionate percentages of immigrants of color ultimately being deported.
Thank you so much for sharing that, Wendy. What happens on the criminal justice side if an immigrant is accused or arrested of a crime? And how is a criminal case impacted if someone is taken into ICE custody?
So since the introduction of secure communities in 2008, when someone is arrested and fingerprinted and those prints are sent to the FBI, those prints are automatically shared with ICE's database. So ICE immediately gets notification of somebody's arrest within the criminal justice system. If the person's prints show up in the ICE database, ICE officials can then decide whether to issue an administrative arrest warrant for the person or an immigration detainer. If ICE decides they want to arrest the individual, again, most likely for a civil, not criminal violation, they will either try to arrest them on the street, at their workplace, or at their home, or if the person is in criminal custody, ICE will issue what's called an immigration detainer. A detainer asks the jail or prison or police station, wherever the person is being held in criminal custody, to notify ICE before the person's released and to hold that person for up to 48 hours in order for ICE to get there. That's only if that's lawful. Holding someone for ICE is unlawful under some state and local laws, but I believe all states and localities allow ICE to at least be notified that that person is going to be released in the near future. ICE often tries to arrest individuals that have been identified through the criminal justice system while their criminal cases are still pending. This has a significant impact not only on the due process rights of the individual, but also on the administration of justice. If ICE arrests someone and detains them, they can then be held in any ICE facility in the country, and their immigration proceedings will not wait for the outcome of the criminal case. If they're held in ICE custody far from the criminal court where the case is pending or in another state, ICE will not bring them back to criminal court to resolve their pending case. That pending case will then be treated as a negative factor in the immigrant's deportation proceedings and will likely cause denial of any discretionary relief from deportation, even if the person ultimately is innocent or the case would have been dismissed if they'd been able to return to court. To compound this issue, if somebody is deported, based partly at least on that pending criminal case, that individual will likely never be allowed to lawfully enter the US again because they have an open criminal warrant for the pending case. I have heard of so many cases over the years where the victim was in court saying they wanted the case dismissed, they didn't want the person prosecuted, or even the person wasn't guilty and that it was mistaken ID or it didn't happen the way they said it did, but the court wouldn't dismiss the criminal case because the non-citizen wasn't present in court that day because they couldn't be because they were in ICE custody.
Thank you for sharing that. And for my next question, I'm going to turn to the Laken Riley Act, which for the benefit of our audience, you may have been hearing about the Laken Riley Act in the news. We do have a rapid response video that specifically addresses the Laken Riley Act and goes into a lot of details about what it is. So if you want to learn more, you can watch that. It's part of this rapid response web series. But Wendy, I'm wondering if you can share with us, what do you see as the potential impacts of the Laken Riley Act on non-citizens and on defense counsel?
So the Laken Riley Act is going to have significant impacts on immigrants, particularly immigrants of color, who, as I said before, are arrested more frequently for low-level theft offenses, for example. Laken Riley requires mandatory immigration detention for many categories of undocumented immigrants who've been charged with low-level theft offenses such as shoplifting, as well as some assault crimes. Very importantly, it does not require a conviction or even a finding of probable cause that the crime was committed. The act does not consider what happens if the police drop the charges or the individual is found not guilty or the case is dismissed. It also presumably applies to children, although there are arguments that it should not apply to those charged in juvenile court. Laken Riley really complicates the work of criminal defense attorneys who are responsible for representing their clients on the criminal charge. For example, most people charged with low-level theft offenses are not held on bail and are either released by the police after their arrest or upon arraignment, their first appearance in criminal court. For those arrested by ICE under Laken Riley, they may never make it to court at all because they're subject to mandatory detention just for being charged with the crime. So as soon as the police arrest them, ICE can then arrest them under Laken Riley and hold them on mandatory detention. So they may never make it to court at all, or if they're released at arraignment, for example, for larceny or a shoplifting offense, they will not make it back to criminal court to defend against those charges because they will be held in mandatory immigration detention. Criminal defense attorneys are required by the Supreme Court under a case called Padilla to advise their immigrant clients about immigration consequences of the criminal case. Laken Riley makes this advice much more difficult to give and complicates a defense attorney's job. Defense attorneys, for example, may be in a position of asking judges to hold their clients in criminal custody, even for low-level offenses, so that they can have the ability to adjudicate the case and have an opportunity to go to trial. As I talked about above, once arrested by ICE, they will probably not be able to return to court to answer on that charge. For clients, they may be arrested by ICE right from the police station, never make it to court at all. Also, defense attorneys are not immigration experts, yet they're required under Padilla to advise their clients about immigration consequences. Some defense attorneys have access to immigration experts, but many do not. Figuring out whether a client falls under Laken Riley will often require a complex analysis of the client's immigration status and history, or at a minimum, a strong understanding of immigration law. For example, the provisions of Laken Riley presumably apply to individuals who entered the U.S. without permission, but were subsequently granted some form of temporary lawful status, such as DACA, TPS, paroled into the United States. This potentially applies to millions of immigrants in the U.S. today. Defense attorneys will also need to advise clients potentially subject to Laken Riley at the earliest opportunity, which usually means at arraignment, because again, if the judge releases them, they may never see the client again. At this point, clients may not have all the information needed to do a proper analysis of immigration consequences, and defense attorneys probably won't have access to immigration expertise. But if the client is not in criminal custody, they can be arrested by ICE at that point. So immediate and full advice to clients at the first opportunity is critical. I want to note also that there is no right to appointed counsel in immigration proceedings, and the overwhelming majority of non-citizens in immigration detention, so all of those subject to Laken Riley, end up representing themselves. So the criminal defense attorney may provide the client with the only immigration advice they will ever receive.
Mm-hmm. And the Laken Riley Act is predicated on the goal of protecting victims of crime. In your opinion, are the interests of victims being served by this legislation?
I would say no. And as I talked about a couple minutes ago, Laken Riley is going to cause many non-citizens to be arrested very early in the criminal process, sometimes even before they appear in court to answer on the charge. This is going to prevent criminal courts from adjudicating these cases, and victims will be prevented from having their voices heard about the impact of the crime on them, seeing the perpetrator punished, or obtaining any kind of closure. These cases may remain open indefinitely. This act substantially interferes with criminal courts and their ability to function. The increasing rhetoric around the necessity for ICE to arrest and detain immigrants who've been involved in the criminal justice system because they're a public safety risk also misses a very important point. The criminal justice system is designed to prosecute and punish criminal behavior. Prosecutors, police, and judges are focused on and presumably are experts in public safety and public safety risks and what are appropriate punishments for those convicted of crimes and when it is safe to release someone to the community. In contrast, ICE is responsible primarily for prosecuting and removing non-citizens who've committed civil violations of law, being in the U.S. without lawful presence. They are not experts in public safety. When a judge decides that someone should be released on bail, or after serving a sentence and deciding what an appropriate sentence is for a particular crime, that individual is no longer considered a public safety risk by the criminal justice experts in the criminal justice system. Obviously, as with any native-born U.S. citizens, the criminal justice system sometimes makes mistakes, but that doesn't mean that every immigrant who's been released on bail or has already served their sentence and paid their debts to society should be arrested and detained again in civil immigration enforcement. ICE are not public safety experts and should not override the decisions of those in the criminal justice system whose job it is to be such experts. And Laken Riley really makes immigration officials makes them become experts in public safety risk, which is not their job.
Thank you so much for sharing these insights and this information with us today. To wrap up, what should the criminal defense bar be aware of to best advocate for immigrant clients?
So criminal defense attorneys really need to have access to crim experts. Crim experts are those who specialize in the interplay of immigration and criminal law. Not all immigration experts have that expertise, or immigration attorneys have that expertise. As soon as they meet their clients, defense attorneys need to determine their client's immigration status and consider what may happen if they're released from court that day, or if they post bail while their cases are pending. Because as we've talked about, they may be arrested by ICE and then never come back to criminal court. They need to understand the impact that convictions on the pending charges would have on their immigration status, whether the convictions will make the clients deportable or bar defenses to deportation, and the impact on their ability to apply for lawful status or citizenship in the future. Public defender offices around the country lack sufficient access to immigration experts who can advise them on their immigrant clients, and they definitely need more funding for this. As for private defense attorneys, they should really include in the cost of representation fees to pay an immigration expert when representing non-citizen clients to help them properly and fully advise their non-citizen clients about immigration consequences stemming from the criminal case and trying to minimize those consequences as they are constitutionally required under Padilla to do.
Thank you so much, Wendy, for this conversation, sharing your expertise, and for shedding light on some of these common myths perpetuated about immigrants and crime, and for explaining for us the interplay between the immigration and criminal justice systems. Thank you, Wendy. And to everyone who's joined us today, thank you for being part of this important dialogue. The issues that we've discussed are complex and challenging, but by coming together in spaces like this, we're taking meaningful steps towards progress. And remember that the work doesn't stop here. It continues with the actions that we take in our communities, in our workplaces, and within the ABA. So I encourage you to all stay involved with the ABA's Civil Rights and Social Justice section and become a member if you aren't one already. You can visit our website, explore upcoming events, and consider joining one of the committees to help shape the work that we're doing. Once again, thank you so much for watching. Together we can and will make a difference. Thanks, Wendy. Thanks, everyone.
Thank you.